Power of the President or the Executive Power. Article 7 of the 1987 Constitution talks on the Executive Department. Section 1 says that the executive power shall be vested in the President of the Philippines. Now, Section 17 also says that the President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. In the case of National Electrification Administration versus Court of Appeals, here, the government employees' salaries were raised by a joint resolution of Congress. President Ramos issued EO number 389 to implement the final year salary increase authorized by the joint resolution. EO 389 called for a two-tranche salary increase that would be on January 1, 1997 and the other on November 1, 1997. But NEA implemented the salary increase on January 1, 1997 in a single lump sum. NEA accelerated the implementation by paying the second tranche starting January 1 instead of November 1. Now, COA issued notice of suspension and notice of disallowance against NEA. Now, the issue revolves on whether or not NEA may accelerate the implementation of the salary increase. The Supreme Court ruled that NEA's act is not in accordance with the law. NEA's claim that RA 8250, otherwise known as the General Appropriations Act of 1997, serves as their legal basis. But the court said that the 1997 GAA is not self-executory. So, budgetary appropriations under the GAA do not constitute unbridled authority to the government agencies to spend the appropriated amount as they may wish. In relation to our topic, which is on the executive power, President may approve the expenditure program subject to certain policies and rules. The salary adjustments as well as the associated benefits granted by the Salary Standardization Law 2 are under the 1997 General Appropriations Act, expressly subject to the President's approval. Now, in the case of Villena versus Secretary of Interior, the AOJ here, upon the request of the Secretary of Interior, conducted an inquiry into the conduct of Villena, Mayor of Makati, as a result of which the latter was found to have committed bribery, extortion, malicious abuse of authority, and unauthorized practice of law profession. The respondent here, Secretary of Interior, recommended the suspension to the President, which was verbally granted. Then, the Secretary suspended Villena from office. The issue of the case is whether or not the Secretary of Interior has jurisdiction or authority to suspend and order investigation over Villena. The Supreme Court ruled that the Secretary of Interior has the power to order investigation and to suspend Mayor Villena, provided in Section 79, Paragraph C of the Revised Administrative Code, which was interpreted in relation to Section 86 of the same code, which granted the said Department of Executive Supervision over administration of provinces, municipalities, and other political subdivisions. However, unlike this power to order investigation, the power to suspend a mayor was not provided in any law. There was no express grant of authority to the Secretary of Interior to suspend a mayor. Nevertheless, Section 2188 of the Administrative Code granted the provincial governor the power of suspension. Yet, this does not mean that the grant precluded the Secretary of Interior. Now, in relation to our topic, executive power, the doctrine of qualified political agency says that the act of the department secretaries performed and promulgated in the regular course of business are unless disapproved or reprobated by the President, presumptively the acts of the President, which means that the power to suspend may be exercised by the President. It follows that the heads of the department under her may also exercise the same, unless the law required the President to act personally or that situation demanded him so, because the heads of the departments are assistant and agents of the President.